my son wants to file for his dad, but the father's name wasn't added at birth. What can he use to prove there is a relationship? All right, so there's two things. One is if the father's name was not put on at birth and the father was married to the mother, the best way to prove the relationship is take a blood test. It's my biological father. However, in a lot of circumstances, the father was never married to the mother, which is why the father's name was never put on at the time of birth. If that is the case, then you need to prove not only that you're the biological father, but that you had a relationship with the child from birth to 18. So how do you prove biological if the name wasn't put on? Well, you're going to have affidavits from the mother and other people who know that the father is the father because they were there at the time of birth. They can say, yes, I was there at little Timmy's birth, and I remember his father, John, was ecstatic. He was passing out cigars to everybody, or whatever they can say that they know that when little Timmy was born, and I don't know, nobody's named little Timmy anymore, I just made that up. But when little Timmy was born, they know that little Timmy's dad, at the time of the birth, he was yelling it out to everybody. I'm the father, I'm the father, I'm the father. That's how you prove that he is the father. You get affidavits from people to say that he acknowledged that he was the father contemporaneously with the time of the birth. Now, sometimes immigration accepts those letters, sometimes they don't. If they don't accept those letters, then you're going to take a blood test. But you're going to submit those letters first and wait for immigration to say, we don't buy those letters, take a blood test, and then you'll do a blood test. Now, unfortunately, they discriminate against fathers who were never married to the mother. In addition to proving you are the biological father, they want you to also prove, as a father who was never married to a mother, that you have a relationship with this child from birth to 18. So how do you prove that? Well, here, I'm in pictures with little Timmy. Here's dad and little Timmy in pictures together. Here's dad sending money for little Timmy's support. Here's dad on little Timmy's school record showing he's the father in case of an emergency. Here's dad on the baptismal certificate. He was there at the time of the baptism. Here's affidavits from people saying that dad's a great guy. He used to come by and, play football or soccer with little Timmy after school every day. Whatever it is. So, it's going to be a combination of affidavits and documentation. Maria Jo with a question. Squad up, Uncle Brad. I filed the I-751 and me and my husband are unemployed due to COVID-19. Does it impact my green card? No, it does not. On the I-751, your unemployment does not impact the green card because there's no poverty guideline requirements for the I-751. The only requirement for the I-751 is that you and your husband are in a bona fide marriage. That's all you have to prove, whether you're working or not working. Danny K with a question. Hey, Brad, do you know if the United States is accepting international B1 now from the Caribbean, not on the travel ban list? Please, thank you. If you can get on an airplane, I do not believe I have ever read anywhere that they are not accepting people from the Caribbean. It's a matter of getting on a plane and getting to the United States. But from the Caribbean, I've not seen a ban. The ban right now is Canada, all of Europe, and most of Asia, and Brazil, and Russia, and China, which is part of Asia. But I have not seen anything from the Caribbean. Agawa Torre. Hi, Brad. My cousin's interview was canceled. It was March 26, 2020 because of the corona. Her medical records were sent to the embassies overseas. Do you think she will have to do it again? It's very possible she'll have to do it again because the medicals are only good for 6 months. So if it's more than 6 months, unfortunately, they may have to do it again. Razak Mustafa. I am a volunteer departure. I'm married. I'm on voluntary departure. Okay. I'm married and adjust my status. My I-45 was denied. My I-130 was still pending. What should I do? Sounds like you need a lawyer because if you took a voluntary departure, you need to reopen your deportation case, which is why your I-45 was denied. You can't take a voluntary departure. Voluntary departure is when you're in deportation and you say to the judge, Judge, don't put me in handcuffs. Don't put me in jail. I promise you in the next 30 days, 60 days, 90 days, I'm going to leave the country and I want to go on the airplane like a human being without any escort. And when I get to my home country, I'll go to the embassy and show you that I'm there and I'm voluntarily leaving. Now, when you don't do that, when you don't voluntarily leave, it automatically turns into an order of deportation or removal and bars you from adjusting your status for 5 years. So if you take a voluntary departure, you have to reopen your voluntary departure within 90 days. If you do it beyond 90 days, you don't do it through the judge. You have to do it through a joint motion with the immigration trial attorneys, and you got to be able to show them a lot of hardship on why this would be a terrible, terrible thing if I did not get my deportation case reopened. That is why your I-45 was denied and why your I-130 is pending. You're not eligible to adjust until you reopen your deportation case. So whoever's filing or whoever's advice you're following to do what you are doing, you're doing it wrong. Call me. Excuse me. Alam Aga with a question. Hi, Brad. I'm a United States citizen. I separately filed the I-130 for my wife and children, 5 and 6, and both documents got approved. I paid and accepted at the National Visa Center on February 4th and March 8th, 2020, but they're waiting for consular offices to open and send the appointments to schedule. Please explain. Okay. There is something that is going on in the world right now. It's called a pandemic. It starts with a virus that started in China that's spreading around the world. And as a result, many, if not most of every embassy, U.S. embassy that is processing immigrant visas, those embassies are now closed. There was a 60-day moratorium on immigrant visas processing by Donald Trump. That moratorium is up, but you got to still wait for the U.S. embassies to reopen. Until they reopen, there's not a human being who can process these cases. Now, you're a United States citizen, so the moratorium on children and spouses of U.S. citizens were not part of Donald Trump's moratorium. So with or without the moratorium, your wife and children should be able to come. It's a matter of get somebody in the U.S. embassy to work there and open up and do it. That is what the problem is. And it all relates to coronavirus. Tijaz Desai, hello, Brad, sir. Any updates on ban of family visas? I just updated you. Rupan Thakador, hi. When the National Visa Center accepted all the documents and they're waiting for the interviews abroad, so during this time, the green card holder spouse can visit the foreign country and the interview date is late. The answer is yes. If you have a visitor's visa, you can go visit, but you've already showed an immigrant intent by filing the paperwork. So there's always a possibility when you come into the airport that they give you a hard time or even deport you for having an immigrant intent. So you got to be very careful traveling, what you're saying, and what your plans are for coming to visit. So the answer is yes with a little asterisk. RR. Hi, Brad. I was arrested in New York for a controlled substance 6 years ago. I received an ACD. Case was dismissed after 6 months. Can I apply for citizenship now? Yes. If the ACD was dismissed more than 5 years ago to this day, you can apply for citizenship. Absolutely. Safi, and the reason is because then you have 5 years of good moral character. Safi Darbor. Hi, Brad. I have an approved VAWA on my EAD, the category C31. What does that mean? And when should I expect my interview? C31 means your I-360 was approved. So you're getting your work permit as a result of having an I-360 approved. When you're getting an interview, I don't know. Did you file an adjustment application? If you didn't file an adjustment application, you're never getting an interview. Magic 8 Ball. Safi Darbo. I have no idea where she filed, if she even filed an adjustment, where it is, when it was filed. I didn't handle her case at all. All I know is she has a work permit with the C31. But with all of that information that I know about Safi Darbo, that all she has is a work permit with a C31 stamp, Magic 8 Ball, when will Safi get her green card? And the Magic 8 Ball says, my reply is soon. That's what the Magic 8 Ball says. I just literally repeat what the Magic 8 Ball says. Kamar Solomon with a question. Charged for theft in the home country. I paid a fine. No jail time. Would that affect my adjusting status married to a U.S. citizen? Yes, because by paying a fine, you pled guilty to a crime. Whether or not that is a petty offense, whether or not that's a crime of moral turpitude or an aggravated felony, I have no idea. We have to see what you pled guilty to. So the answer is it absolutely will affect you. A, because it may make you inadmissible. B, it certainly goes against good moral character. Let's see. Seema Rahman with a question. Me and my husband had an individual interview in Atlanta court. USCIS came to our house to ask questions. 45 minutes after a few months, they put my husband's case again to a master hearing. Can you tell me why? I think that after you had your individual hearing, they came to your house to investigate to make sure that you're in a bona fide marriage. Hopefully you are. I don't know what the individual hearing was for. Was it for an adjustment of status? Was it to prove that you're in a bona fide marriage for the I-130? So I'm not sure what the individual hearing was for, but I presume that if you got scheduled back for a master calendar, either the immigration judge will rule for you to be able to adjust your status or terminate your proceedings to allow you to file an I-45 locally with the Atlanta office. So I'm not exactly sure why, what's going to happen at the master calendar hearing, because I'm not sure what the individual hearing was for. But presumably, if everything went well on your interview when the USCIS came to make sure that you're in a bona fide marriage, I assume you should be okay. Denise Johnson with a question. Hey, Brad, my mother-in-law passed away in Jamaica. I did my citizenship, but I never got to do my swearing ceremony because of the pandemic. Can I go? If I will go, will there be a problem? You can go to Jamaica. And by the way, my condolences. You can absolutely take a trip to Jamaica. Just don't do a trip for more than 6 months. You can go for a month or two. Absolutely. Let's see. BB with a question. We got annoyed. She didn't get annoyed like I'm annoyed. Oh my God, I'm angry annoyed. She got annoyed, which is a notice of intent to deny. Gotta be careful when we say I got annoyed. Like Jilly was annoyed with me earlier, but she did not have a notice of intent to deny. We got annoyed for an I-45 asking for proof that I went to a conference I came to the United States for. Is it wise to include more evidence of our bona fide marriage as a marriage based on adjustment of status a year after the interview? They're not asking about the bona fide marriage. They are asking whether or not you went to the conference that you were supposedly coming to on your visa. And the reason they are asking that is if you did not go to the conference that you were supposedly coming to for the visa, then you committed a misrepresentation. You came to the airport, said, here's my visa, I'm coming to a conference, and you never went to that conference. They're going to deny you for misrepresentation. So as long as you have proof, just with immigration, you only answer the question that they ask. Don't submit documents that they're not asking for. They're not asking for proof whether you're in a bona fide marriage or not. They're asking for proof. Did you make a misrepresentation when you came into the airport? Did you go to that conference or you did not? Because if you didn't go to the conference, then you lied. What's your purpose of coming to America? And they're going to deny you for misrepresentation. And then you would need a waiver. So just answer the question. You don't need to submit proof of the bona fides of your marriage. They're satisfied you're in a bona fide marriage. They're not satisfied that you told the truth when you came into the airport at this point. Becky Hallelujah with a question. If a 12-year-old boy is on medical, does it affect his adjustment of status? He can't be put on his stepfather's insurance due to not having Social Security number yet. It does not affect, I guess you're talking not medical, Medicaid. Medicaid for children under 18 does not affect poverty guidelines, if that's your question. So the answer is no, it should not affect. Kiki Agakun. Kiki with a question. Hi, Uncle Brad. My partner and I just got married yesterday. We are planning to file the I-130 and I-45. Congratulations. We only have pictures as evidence as of now. Well, you just got married yesterday, so that's fine. When you file your adjustment application, you don't have to submit evidence that you're in a bona fide marriage. You just have to submit evidence that you're legally married. Here's my marriage certificate. Here's the divorce decrees if me or my spouse were previously married. The bona fides of the marriage happen at the interview, which will be in 9 to 10 months from now. So I presume you're going to live together. And if you live together, I presume you're going to have a financial relationship together, and you're going to have a joint bank account together, and you're going to pay your bills out of that joint bank account, and you're going to do a joint tax return at the end of the year, and you're going to have rent receipts or a home that's purchased in both your names, and you're going to bring all this documentation. You're going to be able to do 6, 8, 9, 10, 11 months of documentation of proving you're living together, and you're going to bring all of that to the interview. So don't worry that you only have pictures now. Nobody expects you to have anything other than a picture. You just got married yesterday. Mashwal Sawal with a question. I don't understand why the U.S. Embassy in Ghana refused me a visa after they sent me an email that I have overcome the public refusal. Well, Mashwal, I don't know either why they would refuse you a visa after they overcome. I don't know what the public refusal means. I guess you mean public poverty guidelines. I'm not sure what you mean by public refusal. So I don't know why the embassy denied you either. I don't even know what visa you're applying for. So you're asking me to tell you why the U.S. Embassy denied you. The only way I can figure that one out would be for you to call me, and then I would call the U.S. Embassy in Ghana and speak to somebody there and say, hey, my client, Mashwal Shawal, why was he denied? And they'll tell me. And then I'll talk to them and say, well, how can we overcome this denial? And we'll figure out if we can overcome the denial. But if you're asking me why they denied you right now, I don't have the slightest idea. Kiki Agacum. My I-94 expires the middle of the next month. Is it possible to file the I-130, the I-45 now without more evidence? We will definitely get more evidence before the interview. Yes, Kiki, I answered that question. File now. Hill 60. Good evening, Uncle Brad. Is it possible for someone who lives in New York can be an affidavit of someone in Florida? Absolutely. Anyone can give an affidavit of support for anybody in the United States. You don't have to live in the same state. You don't have to be related. All you have to do is prove you're a U.S. citizen or lawful resident. That's the only requirement to give an affidavit of support for somebody. Lynn James with a question. Hi, Brad. USCIS received my I-751 in February. They took my old biometrics and added it in May. How long do I have to wait to get my 10-year card? The I-751s are taking about 18 months, so you're going to be waiting a little bit, unfortunately. Dianba Dial. Hi, Brad. When the application support center going to reopen? They say early July now. Let's see what happens. Let's see what's going on Facebook now. Let me move my phone over here and see what's going on. Maybe the left side is a little better than this side. Or this side. I think this side's better. Janice Williams says, hi, Uncle Brad. My son wants to file for his dad in Jamaica, but his name wasn't added to the... I think I answered that question already. Let's see what else we have here. Colin Beulah-Worry. Good day, Brad. Our SIDGE case was started in October 2019, and for 4 months, nothing was done because of COVID. As of now, we have no idea what is going on. Should it take this long time is the essence? My son's going to turn 20 in November. Yeah, I don't know what's going on either. The courts in New York are closed right now. Hopefully, when we get to phase 2, which is supposed to be Monday, the courts will be open again. Usually, family court hearings in New York take 10, 12 weeks. You know, obviously because of Corona, it's taking a little longer. Yes, I would be concerned. Your son is turning 20. You want to get this done before he's 21, well before he's 21. What you should do is call to have a consultation. I presume the courts are going to be open on Monday, and we can go check if you're in New York what's going on with those cases. Zaida Garcia with a question. Hi, Brad. My mom applied for me 2 years ago. I'm married. I'm over 21. If she retires and decides to live outside the country, does this affect her filing for me? Yes, it does, because you're supposed to be coming to reside with her, and she's not living in America. And number two, she won't be able to give you an affidavit of support, but that's not the end of the world. But then again, you can't ask your mom to live in the United States. Your case is going to take another 12 years. You're going to ask her to live in the United States for another 12 years. So it's a problem. She can go retire back home and then come back as the visa gets closer, for sure. But yeah, if she's not living in America for 12 years, they're gonna have a hard time giving you a green card to go join your mom when she doesn't live in America, because that's the basis of the application. Denise Cromaz says, "Hey Brad, I live in Jamaica. My mom is a U.S. citizen. She filed for me back in March 2013. I was married when she filed. I'm now divorced. The National Visa sent a letter with my case number when I logged on. My ex-husband is still on the filing. I uploaded the divorce paper to NVC. How long will they take to review and remove him from my filing? It should be about 8 to 12 weeks. He should be off the filing, and it should be upgraded to an F1, and you should be eligible for your green card immediately." Akila Logan with a question. "My mom overstayed because of COVID. She has a visa. Will she be affected to come back to the USA on her next visit?" Absolutely, she will. If she overstayed because of coronavirus, that's not an excuse for overstaying. She should have made an extension on her tourist visa. We've talked about it a lot on my show. So overstaying because of corona is not an excuse for overstaying. She could have made an extension. She will not be allowed back in the United States. She would have to get a new visa. Her visa is void now. Phaelanis with a question. "Hi, Brad. Can a green card holder sponsor her married 30-year-old child and still get a B2 visa while waiting for the last 15 years? The daughter and her granddaughter just want to visit from time to time. No intention of staying more than a month, just pure visit." No, if you file, the answer is yes. Anything is possible to happen. But if you apply for an I-130 for your child, it is very, very doubtful that the U.S. Embassy is going to give you a tourist visa, because she's already shown an intent to get her green card. That doesn't mean you can't go. That doesn't mean you can't try. I'm just saying it is unlikely. Adelaide Isam says, "I've been calling the office and no answer." Okay, Adelaide, send us a DM. Either in Messenger or on Instagram right now at Bradshaw Live, and I will have somebody in my office grab your number and call you. Joseph Canuta, "Does the temporary suspension on the green cards affect those outside of the United States whose cases are already processed by the National Visa Center pending interview?" Yes, it does. Enger Ben Ergenyeko. "Please, can someone who filed the I-130 approved file for a K3 if the country with the beneficiary live?" What? "Please, can someone whose I-130 was approved file for a K3 if the country beneficiary is on an immigrant visa ban?" So you're talking about Nigeria. You can, Nigeria, you can file the K3 because the ban is on immigrant visas. K3 is not an immigrant visa. Pauline Blackwood with a question. "Good evening, sir. Brad, is your company open for a person to come in? I'm trying to reach our lawyer. We sent her emails, but she does not reply." Pauline, I don't know why she's not replying. We are working from home. Drop us a DM in Bradshaw Live Instagram, and I'll see to it that your lawyer responds to you. Let's see what else we have here. April Walker, "I was filed for by my sister, who is a USA citizen from 2006. I send in all the paperwork that was requested. How long do I wait for my interview date?" You should be eligible for your green card now for May 2006. I'm not sure what you mean by you submitted all your paperwork or where you're at, but presumably if you've put in all your paperwork, you should be eligible anytime now. Stargirl Mika with a question. "Brad, someone who was deported and was banned ended up getting a one-entry visa to travel after the ban was lifted. Do you think they will have any problem when they get to immigration airport? Was deported after serving time on a drug charge." Well, why did they get this one-time visa? Did the embassy realize when they got this one-time visa that he was deported on a drug charge? because they would not, unless he filed some sort of waiver, he wouldn't be eligible for a visa. If he got a waiver, then he should be able to come to the United States, although presumably if it's a drug charge, you could always be found inadmissible at the airport for being a suspected drug trafficker. So yeah, I need to know more about what happened. Hi, Brad. Good evening. I hear that the 60 days will be extended for immigrants. Will it affect the ones that are at the National Visa Center? If it is extended, it affects everybody. FAPA, but we don't know if it's going to be extended or not yet. FAPA Saru, I'm applying for a green card from EB3 unskilled, but I have misdemeanor C on my record. Will that deny me? A misdemeanor C is not a crime of moral turpitude, so it should be okay. Juliet King with a question. Good evening. Good afternoon, Brad. Bless up yourself. Quite quick question for you. Put in for adjustment of status, and they gave her an 18-month extension. Now her 18-month expired this June. She called USCIS to say if they were about to change her job, she can travel. I don't know if you're talking about an adjustment of status or you're talking about an I-751 to remove the conditions. That's usually when you get an 18-month extension. She can travel. She can work. She can get a stamp in her passport if the 18 months is coming up until they make a decision. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.